Hi, students. How are you guys? This is a short video lecture, and topic is the exceptions to the requirement for a search warrant. I'm going to talk about one, two, three, four of them. There's consent to search, search incident to a lawful arrest, the automobile exception, and also exigent circumstances. Those are the four I'm going to talk about. So remember, there's a preference for a search warrant, but it's not always practical for an officer to obtain a search warrant. So the officer is going to have to find an exception to be able to search. And remember, when the officer is acting without a search warrant, then that search is presumed to be unlawful, and the burden will be on the people or the government to prove that there's an exception to search without a search warrant. So the officers have to be aware of these exceptions, understand what's required, and make sure they comply. Because if they don't, then there's a good chance that the evidence could be suppressed. So it is very important that they understand these concepts. Also, if you're not in law enforcement, again, it's important for you to understand what your rights are so you can protect your rights. So let's talk about consent. Consent means that a person with authority over the property can voluntarily consent to the search of their property by the police. And just go back to contacts, a consensual encounter. A consensual encounter, it has to be voluntary. And again, here, the person, if you know, if they want to agree to allow an officer to search, then they can do that. And there's all kinds of ways that this could come up. For example, an officer makes contact with a person on the street, and it's a consensual encounter, and the officer asks the person, "Do you have any drugs on you?" Person says, "No," and the officer says, "Well, do you mind if I search?" And the person says, "No, go ahead." That's a consent to search. The case I advised you of, Dumb and Dumber, I think is Drayton, where the officer was on the bus. It was a drug interdiction case, and he asked him, "Can I search you?" And he said yes, and they found the drugs, and he was arrested. Of course, said that was a consent to search. Um, let's say the officer makes a car stop for it's a traffic violation. Maybe it's speeding. And during the contact, the officer asked the driver, "Can I search your car?" And if the driver says, "Sure, go ahead." And that's consent to search. If the officer finds something, um, then the person could be arrested for it. So the consent just has to be voluntary. So the officer is going to have to show that it's voluntary. Um, a lot of times, not a lot of times, but on occasion, the uh, officers assigned to investigate drug crimes would receive information that a person was in possession of drugs in their house or selling drugs, but they didn't have enough to get a search warrant. They didn't have enough to search it pursuant to a search warrant, so they would do what they called a knock and talk. I don't hear that much anymore, but the idea was that the officer would go to the house, knock on the door, and talk to the individual and say that they were there to investigate reported drug or health and safety violations or drug violation, and ask if they could come in to speak to the person about it. And then if the person invited them in, that would be voluntary, and then that would allow the officer the opportunity to look around, not search, but to observe what was in plain sight, and then talk to the person and perhaps lead to evidence of possession, maybe writing a search warrant, or the person consenting further to allow a more fuller search of the property. It's called a knock and talk. I don't know if they use them that much anymore. I think there's drawbacks to that, which I will talk to you about in just a second here. So, but remember, The consent has to be voluntary. It cannot be the product of duress, coercion, pressure tactics, or intimidation. The courts are going to look at the conduct of the officer obtaining the consent, the condition of the person giving consent, and the conduct of the person giving consent. So the conduct of the officer, they're going to look at how the officer did it. Was the officer yelling and screaming or threatening, or was he polite and, explaining the case and asking for consent, or was he being intimidating? So the conduct of the officer will be scrutinized. They'll also look at the condition of the person giving consent. They'll look at the person's age. Is there an age limit on a person giving consent? No, but they have to look at the maturity of that person, especially if it's a minor, to determine if he understood what was being asked and he knowingly agreed to the consent. It was done voluntary. They'll look at intoxication, same thing. A person that's been drinking can give consent, but it still has to be knowing and voluntarily made. Same with any injuries, if the person's been injured or has a mental health impairment of some sort. So when you get into those situations, if you're the officer, you got to be very careful because again, you have to show that it was consensual, it was voluntary. How would that happen in court? So sometimes if you're the officer, you don't want to get into a situation where it's your word against another person's word. That's the only evidence. You should try to document or substantiate that consent another way. So what I would suggest, some good ways to do that would be to have another officer present when you're asking for consent. You could audio record the consent. Now they have body cams or dash board cams. You could put them on the camera and ask for consent. You could have them sign a consent to search form. So there are different things. You want to make sure it doesn't come down to your word against the other person's word. You want to be able to substantiate it some way because, again, the burden is going to be on the government to show that it was a valid consent. So it's going to be up to the officer to be able to establish that, and the officer really has to be thinking about that, when they're doing it. And then they're going to look at the conduct of the person giving consent. Was the person very cooperative? So you ask for consent, and the person, come on in. Yeah, sure, I'll show you where that stolen stuff was. Joe put it in my back bedroom the other day. I didn't know it was stolen, but sure, go ahead, take a look at it. Take it if it's stolen. I don't want it in my house. So if the person's conduct is not only giving it verbally, but they're acting in a way that's voluntary, then the court will look at the conduct of that person. So the problem with consent is that the person can control the scope of the consent, which means that the person can say, well, I'll allow you to search the bedrooms, but I'm not going to allow you to search the living room, kitchen, dining room areas. So they can limit the areas where the officer can search. They can also limit the duration of the search. So they can say, well, I'll give you a half hour. That's it, man. I'm not letting you stay here and tear my house apart. You got a half hour to do it. And then also the consenter can withdraw their consent anytime. So the officer might be in the middle of this search and the person says, hey, I changed my mind and withdrawing my consent, you got to leave. And the officer would have to leave. And if they continue to search, then those items would be inadmissible. For those reasons, as a police officer myself, I never relied on consent by itself. And the other thing I wanted to tell you is it's always better for officers to think and have multiple theories to justify what they're doing, multiple theories to justify their search. So if they have a search warrant, they might still ask for consent. If the person is on parole or probation and they're subject to search and seizure, I would still write a warrant. Why? Because you have multiple theories. Because if one theory fails, you have a backup theory that you can rely on. It's redundancy. It's extra protection to make sure that your search is going to be upheld by the court. That's what I would do if I were a police officer. That's the way I would think about it, because especially in a serious case, if you're dealing with a murder or a rape or a robbery, three strikes, something serious, then and you know it's going to be litigated. You know it's going to be there's going to be a fight about it in court, and you want to prevail. You want to see, if you're the officer, you want to see justice done. You want to see, the truth come out, and if the person did it, you want them convicted and you want them sentenced appropriately. So you have a lot of vested in this case, and you want to see it handled appropriately. Then you need to take some extra steps and to make sure that what you're doing is going to be upheld. So those are the drawbacks to consent. Who has the authority to consent? Well, the person who owns or occupies the property by themselves. That's the easiest situation. My car, my house, my apartment, my box, whatever, I can give consent. A joint owner or occupier can consent to the search of the property he owns or occupies by himself, so his own separate property plus the shared areas, unless the other party objects. If the other party objects, then you're going to need a search warrant or some other exception. Um, so that's consent to search. It's pretty straightforward, but there are some things that you have to think about, and I don't know, I'd be concerned about some of the downsides to getting consent. The second exception is search incident to an arrest. When you arrest somebody, and you're going to standard procedure, at least in my department, was you handcuff them behind their back, unless there was some reason not to. And then you searched them. You searched them incident to arrest. Now you search their person, and you could also search the area immediate around that person to look for a weapon or evidence of the crime. So search incident to arrest, you search them, you own them in a sense, and you search them, you search the area immediately around them. The area immediately around them is from the Chimel case, Chimel, Chimel. I call it the leap and reach doctrine. So if the person has the ability to get to a particular area, then you can search that area. So for example, you arrest somebody in their home. It's a domestic violence call. They're in the living room. You're going to cuff them. You search them. You search maybe the couch, the sofa, the table next to the chair, just the area immediately around them. And then the topic comes up, search incident to arrest from a vehicle. Now the law changed a little bit on that. So let's say you stop a guy for driving under the influence, and you give him the field sobriety test. You form the opinion he's driving under the influence of alcohol. You arrest him, you handcuff him, and you put him back in your car. What the law allows you to do, of course, you can search that person incident to an arrest. That's not the issue. The issue is going to be his vehicle. Can you search that person's vehicle incident to an arrest after you arrest the person? Well, it depends. You can search the car if the person still has access to the car after you have arrested him. So does he in my example? No, he doesn't, because you've cuffed him and put him in the back of your police car. So he doesn't have access to his car. So you cannot search his car based on that. The next question you have to ask yourself is, can I search the car for evidence of the arrest crime? So I arrested him for a DUI. Can I search the car for evidence of the DUI? The answer is yes. There could be alcohol or drugs or both in the car, so I could search him. Let's change that for a second. Let's change it to, you've arrested him for driving without a valid driver's license, and you've cuffed him and put him in your car. Can you search the car incident to arrest because he has access to the car? Nope, he's cuffed in the back of your car. He doesn't have access. You cannot do that. Can you search for evidence of the arrest crime? Well, no. The crime is driving without a license. There's no evidence that you can search for, so you're not going to be able to search the car incident to the arrest. So when you arrest someone from a traffic stop and you want to search the car, you have to ask yourself those two questions. One, does he have access to the car? And then secondly, is there evidence of the arrest offense in the car? So the answers to those questions will dictate whether or not you can search the car. I want to talk to you about the third exception, and that's the automobile exception to a search warrant. The police can search any part of a vehicle without a search warrant whenever they have probable cause to believe the vehicle contains contraband or evidence of a crime. The reason for this exception is because a vehicle is mobile. It's on the street, it's capable of being moved, so the courts have carved out this exception to the requirement for a search warrant. But you have to have probable cause. Now, if the car's, for example, not on the street, like during a car stop, that's generally where this is going to happen, a car stop. Like, for example, the car's parked in the garage. No, you'd need a search warrant because you're going to have to enter the property, enter the garage, and then search the car. You'd need a search warrant for that. Generally speaking, what I'm talking about is a car stop. So you make a car stop. Maybe this car was, there was a robbery of a store. You have a description of the vehicle, and you're, 3 or 4 blocks away, and you hear the broadcast over the radio, and then you look up and you see the car drive by you. That's happened to me many, many times as a police officer. And so you pull the car over and you know that there's items that have been stolen. Do you have probable cause to search that car? Sure. So you can search the car. If you smell the odor of fresh marijuana coming from the car, you could search the car. You just have to have probable cause. So the cautionary thing about this is if this not only applies to cars, but also apply to boats and planes, any kind of transportation item, uh, transportation or mode of transportation. So motorcycles, cars, trucks, boats, planes. Now, a question comes up: what if this vehicle, whatever it is not being used as a vehicle, but it's being used as living quarters? So, for example, the car is parked in a campground, and the person is actually using it like to sleep in there, to change clothes. He's using it more not for transportation but for living purposes. What about a boat that's docked, has a berth, it's docked, it's connected to power, to water, to sewer, to utilities. It's not being, sailed on the lake or wherever this is at, but it's being used as living quarters. Well, the answer is if it's used as living quarters, you treat it just like a house, and a house would require what? It would require a search warrant. So you treat it like a house. Okay, so that's the automobile exception to a search warrant. That comes up all the time, and most of the time, like I said, it's going to come up on a traffic stop when the officers have probable cause. And the last one I want to talk about is exigent circumstances. When there's an emergency, that's what it means. Officers can take swift action and search if there's imminent danger to life, damage to property, or destruction of evidence. Case include things like domestic violence. So if you get a call of domestic violence and you respond to the scene, you hear the violence happening inside the house, you can go in. It's an emergency. If you suspect there's a lab where they're cooking methamphetamine, you could go in as an emergency. If someone's injured or hurt, you could go in if it's an emergency. So if you treat it as an emergency, then the courts will most likely uphold it as an emergency. All right, so those are the exceptions. Those are all I want to cover. There's other ones: probation, parole. There's administrative search exceptions. I'm not going to cover those, but I think you get the point. Those are the 4 big ones, and those are the ones I wanted to cover with you today. So Anyway, take care and hope everything's going well. And I'll be talking to you soon. Bye.